I hope I heard that correctly.
I'm not sure you did. Here. Okay, I'm moving this a little bit closer. Can you hear me?
Yes.
Okay. So I was asking you if you had had a chance to review an advice of rights form. You would have found it online.
I've read it on a paper.
Okay.
The 14B paper sent in the mail.
Okay. Do you have any questions about your rights?
Well, I called in and I said I wanted a court-appointed attorney, and she said it was just an arraignment.
Okay, we do have an attorney here to represent you.
Okay. That's good.
Okay. The court is going to enter a not guilty plea on your behalf, and the assistant public defender is going to address bond for you.
Okay, yes, I want to plead not guilty.
Okay. And your public defender is going to be in touch with you.
They're going to be in touch with me for the new date?
I'm going to tell you the new date right now. The public defender will be in touch with you.
Okay, let me get my pen. I know I got it here. Okay, what's the date?
Okay, your next hearing date is going to be January 3rd.
2024.
Correct, and that's at 9 a.m.
9 a.m.
Okay, that will be over Zoom. And you will get a notice of hearing.
In the mail?
Yes. And I believe if you have questions about that as well, you can also address those with your public defender. Okay. At this point, we are going to issue a personal recognizance bond. Okay, that does mean that you are promising to show up for your next hearing, and if you fail to appear, a bench warrant can be issued for your arrest.
Oh, I'll be here.
Okay.
I want to have a hearing.
If you would like to.
No. You've asked for one. I'm just here. I am here to serve.
January 3rd, 2024 at 9 a.m.
Yes. Excellent. Thank you.
Thank you, Your Honor.
Okay. You're welcome. Thank you.
Okay. What
was that?
Public Defender Lauren Kearney on behalf of Mr. Williams. Mr. Williams, can you state your name for the record?
Martell
please?
Williams.
Thank you, sir.
Your Honor, Mr. Williams is here for a pretrial. He has come to a resolution with Mr. Siller and Ms. Coons. He's going to plead at a count of operating while visibly impaired.
That's correct. Okay. May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? State your name.
Martell Williams. Sir, it is this court's understanding you're going to plead guilty to the charge of operating while visibly impaired. That is a misdemeanor. It is punishable by up to 93 days in jail, up to a $300 fine plus court cost. The court could order any rehabilitative services or community service the court deems necessary. Court could also order your vehicle immobilized. Court could also order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that?
Understand?
Understanding that, still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now you understand that by pleading guilty, you'll not have a trial of any kind.
Yeah.
Has he signed an advice arrest form? Probably not. No, he did. You signed an advice of rights form. Do you have any questions regarding any of those rights?
No.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole? Which one?
Probation.
Okay, were you on probation at the time of this offense? All right, you understand that this could be considered a violation of your probation? Yes? You understand that as such, that other court could sentence you to the maximum allowable under that other charge? You understand that?
Yes, I do.
Understanding that, you still wish to plead guilty to this charge?
Yes.
Has anybody promised you anything other than what's been stated here today on the record?
No.
Anybody threaten you or coerce you?
No.
Doing this voluntarily?
Yes.
Of your own free will?
Yes.
And because you believe that you are indeed guilty?
Yes.
May 25th, 2023, at the location of Michigan Avenue, Pittsfield Township, Washington County, State of Michigan. Were you operating a motor vehicle?
Yes.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes.
What'd you have and how much?
I had like a beer and a half the night before and like a 12-ounce when I woke up.
Okay. Were you stopped by the police or was there an accident?
No, I was just pulling over because of the construction that they had. So when I was sitting there, the police just came up and was asking me what was going on.
Okay. You're not disputing the right of the police to stop you in this instance? Okay. Were you ultimately arrested?
Yes.
Were you taken to the hospital?
Hospital, yes.
Okay, was there a blood draw? What were the results of that blood draw?
I never seen the results, but after that, I came here.
Okay. If I told you it were 0.186, counsel, would you stipulate to that?
We would, Your Honor.
All right. Do you have any reason to dispute those blood test results?
No.
All right. Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
I don't think it was, but.
Well.
Wait, what?
You don't want to plead guilty?
Oh yeah, I do want to plead guilty, but I wasn't like drunk or nothing. But, you know.
Really?
You're a 0.186. So you think that
I don't know.
you could, hold on a second, you are a 0.186. And so if you were operating that motor vehicle, you don't think others would have noticed that you were impaired?
Well, probably yes.
Okay, so I'll ask the question.
Coming from the police, yes, yes.
Yeah, okay, so let me ask the question again. Taking everything into consideration, on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes.
All right. Counsel, have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Defendant is referred to Von Swartz for an alcohol screening and assessment and the victim's impact panel.
I'm supposed to do that tomorrow at 1:00 over the phone.
Where?
On the phone at 1:00,
What?
the assessment.
Okay.
With care?
It's through Washington County, I know that.
Okay. Do you have another pending case?
No, my probation officer,
So,
well, Mr. Coons knows this already, but
So somebody's giving him another assessment, so.
okay.
Sentencing in this matter, April 10th, 2024, 9 a.m., or as your invite indicates.
Before you give away the file, Your Honor, there's a bench warrant in the file for a bond violation.
There is.
Granular violation. Mr. Williams and Ms. Coons did speak of it. about it. They would like to set it for a hearing. He does deny the allegation of consuming alcohol at this time.
The two. He wants all of that, he wants it set for a hearing?
Yeah.
I'm gonna move to dismiss it.
The bond violation?
You said it.
Yeah. Well, I'll tell you what. Does he really want to do that?
I don't want to get into it necessarily, but I mean, the level was very low. He thinks that there was another reason of
Oh, boy.
why it detected.
It's gonna be so bad.
Alcohol. It was
Much like not being visibly impaired.
a hair product. Yes.
Because when I got
Oh, really?
when I got released from jail on the 7th
I'm not actually drunk, and I can prove it. I blew beneath the legal limit just this morning.
of last month, I got my hair.
Okay, what kind of hair product?
When I read the bottle afterwards,
Yeah, I know. What kind of hair product?
Tequila.
conditioner.
Conditioner? So that had alcohol in it. A lot of alcohol.
Whatever.
Hold on. It had a lot of alcohol in it. Is that what you're telling me?
That's all it could be because they told me to
Really? Okay.
change my,
So I don't know how to say this. I kind of know about your hair. Just saying. And if you put too much alcohol on it, other things happen. Like you don't have hair because it will break off and fall out. So I'm looking at these numbers here, and yeah, they're low for the human body, high for hair.
Well, Your Honor,
No, I want to have a hearing.
if you would like to,
No. You've asked for one.
I do.
I'm just here. I am here to serve.
I did hear Mr. Stiller say he'd be willing to dismiss.
I know, but I'm not.
Okay. Then we will hold the hearing.
Yes, we'll have a hearing. Give me a date. I need a date before April 10th so that the findings of the hearing can be taken into account at sentencing. Let's do it on trial week. At the end of this month.
Okay.
What day?
We can do Wednesday, March 27th at 1 p.m.
Okay. So bond violation hearing on hair product. March 27th, 2024. Okay. I can't wait.
Is that 27? 24.
27.
All right, and
We're gonna bring some people from the shop, barber shop. They'll be able to tell you. I'm just saying. Okay, we'll see you then. What else? Is there something else?
I would ask that the warrant be recalled
Oh,
pending the hearing.
sure.
Thank you.
We'll recall the warrant.
I got other cases.
I'm good.
So just curiosity, after the conditioner, did you put something else on your hair?
It was. I mean, when I got out of jail,
Okay, no, never
I
mind.
got
Never
my hair-
mind. We'll figure it out at the hearing. All right, talk to you. All right, bye-bye. What? I know. I didn't expect it. Court calls the case of the People versus Shanetta Prescott.
Wow, that was epic!